This conference will now be recorded.
All right, we're going to go ahead and get started. Good afternoon, everyone. I'm Olivia Liebnick from the law offices of Paul A. Lang. Just want to start by thanking everyone for joining us today for the Tools for FBO Survival of COVID-19 webinar. Welcome to our webinar. We hope that this webinar provides you with some tips and information that aids in your FBO survival during these difficult times. In addition to the three presenters from our firm, we are lucky to have Patrick Moylan from FBO Partners with us. Patrick has over 25 years in the aviation industry in safety management roles. He is going to be talking to you about keeping your employees safe during the COVID-19 pandemic. Following Patrick, we have Amber Monk. Amber is a paralegal with our firm who has been assisting our attorneys in providing COVID-19 related advice to our clients over the last month and has witnessed the evolution of those benefits as the recent legislation has been passed and implemented. She is going to be talking to you about the COVID-19 related benefits you are required to provide to your employees. Next, we'll have Paul Grocke. Paul is an attorney with our firm whose practice focuses on providing our clients with assistance in transactional matters, such as buying and selling aircraft, as well as negotiating leases and litigation, specifically litigating contractual disputes. Based on this experience in both transactional and litigation matters, Paul is uniquely situated to give you advice on navigating the impact that COVID-19 has on your commercial contracts. Paul will be talking to you about force majeure clauses. Last up, we have Allison Squigimaro. Allison is an attorney with our firm with over 20 years of experience in litigating commercial matters for various parties in the aviation industry, including insurance coverage, airport access, lease disputes, and airport matters. Allison has been leading the firm's COVID-19 response efforts since the early days of February and assists our clients in navigating the rapidly changing environments. Allison will be discussing airport access issues and rent abatements, and will also give you some tips on the relief that can be available to you under the CARES Act. At the conclusion, we will be opening it up for questions and hopefully have a few minutes to talk more. For your convenience, everyone is being muted during this presentation, and we will unmute everyone at the end for those questions. The agenda for this presentation will start off with how to keep employees safe during the COVID-19 outbreak. Following that, we will discuss the benefits you must provide employees pursuant to the Family First Response Act. Following that, we'll discuss the force majeure contractual obligations impacted by COVID-19. Then we'll go over to the rent abatement / airport access issues, and we will wrap it up with the CARES Act and the other relief. And with that, I hand it over to Patrick.
Thank you, Olivia. So first I want to go over what OSHA regulations to start with of what you should be aware of. There is no specific pandemic set of regulations for OSHA, but that doesn't mean that there are not specific regulations that do apply in this situation. First and foremost is the general duty clause. This is literally cut and paste from the first part of the law itself, the Occupational Safety and Health Law. And this is a clause that is used often by OSHA to cite employers when there's not a specific regulation to point to. So essentially, it says that you as an employer need to be able to recognize the hazards that are in your workplace that are likely to cause death or serious physical harm. Clearly, the coronavirus is at this point a well-recognized hazard, and we know that it does cause death and serious physical harm. So the general duty clause very specifically would be applicable in this situation. The next one is the next three actually are specific regulatory standards inside the OSHA general industry, which applies to all the FBOs. If you have this file, which I believe everyone on this call does, these are hot links that will take you to get more information. Essentially, as an employer, you need to have a PPE hazard assessment, which identifies what can harm employees, and then you have to identify what PPE they should be wearing, and then it is your obligation at that point to enforce its use. Bloodborne pathogen would apply in situations such as if you have first aiders. Also laboratory, there's a level of risk there as well. So that standard would also applies in the FBOs. And then general environmental controls are things like you have to have a certain number of bathrooms, for example, and you can't have debris lying around. That is a specific set of requirements that you can click on that and read through. But these are the ones that really will make sure that you are compliant. Now, any safety officer is going to say, just complying with law isn't enough, but it's a really good start. And I'll say that for two reasons. First of all, it's really good guidance. It will improve or it will reduce the risk of injury and illness for sure, but it also keeps your company protected as well. If one of the reasons OSHA will stop and visit an employer is based on employee complaints. Not only is there a lot of fear right now, and there are people that I'm reading about now that are contacting OSHA, but also if there's cuts in pay or maybe there's layoffs, oftentimes employees will reach out and talk to OSHA, and you want to make sure that you're covered under your regulatory requirements. And if we can go to the next slide, I'll go over some protective measures that can help you with that. So I always like to start off with the concept of the hierarchy of controls. The best way to eliminate any hazard, or is to reduce your risk, is to eliminate hazards. Whenever that is not possible, we work down the chain to PPE. PPE is considered to be the least effective because it's often not used properly, or it just stops the hazard at the moment before it can injure an employee, whether that's gloves, respirators. So we always want to start higher on the hierarchy of control. So here are some examples of things that would actually engineer out some of the risk. If you don't have to have customers in your lobby, then that just eliminates the transmission possibility. I know that's not always going to be possible, but maybe you can reduce the time. You can revise procedures that remove handing paper from one employee to another employee. So those are ways that you can just engineer out some of those hazards. Now, when you're done looking at your engineering controls, and we go to the next slide, we'll get into some of the administrative controls, which are procedures, policies, training, reminding people over and over again to wash and wipe surfaces, having policies in place that employees only use an assigned pen, for example, get down to that granular, or only one person is going to be touching chalks and cones, and then you're wiping them down at the end of the shift, or having shifts that are only the same people, so that you're cutting down on the potential of cross contaminations. And then the next slide is kind of like your last line of defense, is when you've done everything you can to engineer out the transmission possibility, and you've got as many procedures as you can that will reduce the risk even further, is that whatever residual threats you have left is where PPE comes in handy. So this is I know that some of these things are more difficult to come by right now than others, but whatever PPE that you can have, and I do want to remind folks that you need to have a written PPE hazard assessment, and also you have to have your employees trained, and they have to demonstrate that they know how to use the PPE properly. Misused PPE is often more hazardous than not having PPE because it makes the employees feel like they're protected, and they're not. So make sure that you are in this downtime, make sure people are showing you that they know how to put on the face mask, or they know how to insert the hearing protection, or they're wearing that face shield according to the right procedures. And lastly, I just have there's so much good information out there. I just would encourage you to use, there's a lot of misinformation as well. So these are some really solid resources that I want to just leave you with, and I will be on the call at the end if there's any questions. Thank you. Back to you, Olivia.
Thank you so much, Patrick. That was very informative. Next, we'll throw it over to Amber Monk.
Thanks, Olivia. So I'm going to talk briefly the pretty high-level overview of the Family First Coronavirus Response Act, specifically the expanded benefits that employers do now need to provide to their employees. The FFRC went into effect on April 1st of 2020 and does have a sundown date of December 31st of 2020. It requires certain employers to provide their employees with paid sick leave and expanded family and medical leave for specified reasons related to COVID-19. To be an eligible employer for this, your company does need to have under 500 employees. So if you have 1 to 499 employees, you do qualify for this. It expanded the paid sick leave and FMLA, and I'm going to briefly cover each of those. For the paid sick leave, you are now required to provide your employees 2 weeks up to 80 hours of paid sick leave. The rate of pay that you need to provide employees is dependent on the reasoning behind why your employees are requesting the paid sick leave. So if your employee has been quarantined pursuant to federal, state, or local government, or under the advice of a healthcare provider, and or they're experiencing COVID-19 symptoms and seeking a medical diagnosis, you are required to provide that employee with those 2 weeks or up to 80 hours for a full-time employee at their regular rate of pay. If you have a part-time employee, that number of hours is prorated based on their average hours worked per week. If your employee, however, is requesting the paid sick leave for the care of someone else, so they have a bona fide need to care for an individual subject to quarantine who has COVID symptoms, needs to care for a child under the age of 18 whose school or childcare provider is closed or unavailable for reasons related to COVID-19, or they're experiencing a substantially similar condition, their rate of pay is 2/3 their regular rate for those 2 weeks or up to 80 hours. To qualify for this paid sick leave, the employee needs to have worked for you for 1 day. So you hired them on March 31st. On April 1st, they have become eligible for this paid sick leave. The Families First Coronavirus Response Act has also expanded family and medical leave of absence in adding an additional reason why you can qualify for FMLA. That reason is that an employee is unable to work due to a bona fide need for leave to care for a child whose school or child care provider is closed or unavailable for reasons related to the COVID-19 pandemic. This expanded FMLA offers 12 weeks of leave. Those first 2 weeks are unpaid. However, that employee can elect to use your regular sick leave or the expanded paid sick leave under this act. The additional 10 weeks after that will be at 2/3 the employee's regular rate of pay. Now, if your employee is already on FMLA for another reason, say they had knee surgery and they've been out for 6 weeks, this is not an additional 12 weeks on top of that 6 weeks. So they would have 6 weeks of the unpaid leave due to their knee injury and then 6 weeks at 2/3 of their rate due to this need to care for a child whose school or child care provider has been closed. As of April 1st, the Department of Labor also requires that you post a poster outlining these expanded benefits. There is a link at the bottom of this slide and in the PDF you all received to that poster. If your employees are teleworking, we recommend that you email them this poster. The Department of Labor has a 30-day grace period for companies to kind of figure out all of these new things that have come under this act. However, you do need to be working in good faith. So we recommend posting this poster as soon as possible. We go over to the next slide. I'm just briefly going to cover the tax exemptions and tax credits. So private employers qualify for reimbursement through refundable tax credits as administered by the Department of Treasury for all qualifying paid sick leave wages and qualifying family and medical leave wages paid to employee who takes leave under this act. Their fully refundable tax credit is equal to the required paid sick leave and expanded FMLA. These again are from April 1st to December 1st. So if your employee had taken a sick leave prior to April 1st, you may not necessarily qualify for this tax credit, however, from the April 1st to December 1st. There are 2 links here directly to the IRS where there's a frequently asked questions and the form. If you feel that you do qualify for this, we recommend talking to your tax person. I should also mention that for the FMLA, expanded FMLA relief, that your employee needs to have worked for you for 30 calendar days before being eligible for that relief. With that, I'm going to kick it over to Paul Grocki, who's going to speak to you about force majeure.
Thank you, Amber. And thanks everyone for joining today. Hope everyone's hanging tight among the COVID-19 mayhem out there. The topic I'm going to discuss today is how does COVID-19 impact parties' contractual obligations, focusing specifically on force majeure and force majeure clauses in contracts. So as you're all well aware at this point, governments are placing sweeping restrictions on business. Unfortunately, companies are laying people off in record numbers, and people are avoiding public spaces altogether in certain instances, and unprecedented circumstances leading to unprecedented circumstances in business, especially. So that begs the question: in light of these unprecedented circumstances, what are parties' obligations to honor their contractual obligations when they become unable due to something like COVID, which is outside their control? So a question you may have is, if your contract has a force majeure clause, will that excuse my obligation performance under the contract or the other party's obligation performance under the contract? So if we can go to the next slide. Before digging into that question, just generally, what is a force majeure clause? Well, generally speaking, a force majeure clause is a clause in a contract that excuses or suspends a party's obligation to perform under the contract if a major event beyond a party's control renders them unable to perform. Okay, so then if we go to the next slide, we'll take a look at a sample force majeure clause. So the sample we have here is: an event of force majeure is defined as an act of God, fire, earthquake, hurricane, flood, terrorist attack or threat, storm, washout, wind, lightning, landslide, explosion, epidemic, inability to obtain materials or supplies, or any occurrence outside the reasonable control of the party claiming inability to perform, and which by the exercise of due diligence could not reasonably be prevented or overcome. Neither party shall be liable or responsible to the other party for any delay, loss, damage, failure, or inability to perform under this agreement due to an event of force majeure. So this is, as I mentioned, just a sample. Certain force majeure clauses may lay out even more events that qualify or less. It will depend on the specifics of your contract, so it's important to pay particular attention to the specific language. So if we can go to the next slide, we talked about some of this in the abstract, and the question becomes, does a force majeure clause in my contract actually excuse performance obligations in my contract? Well, the classic lawyer answer is it depends, and it depends on the following generally. What is the language of your force majeure clause? What are the specific facts and circumstances of your situation? And third, the laws of your jurisdiction. So depending on what your jurisdiction you're in, courts may look at different factors or allocate different amounts of weight to different factors. But generally speaking, the factors a court will consider when determining whether a force majeure clause applies to excuse performance are the following. First, does the clause specifically reference the event in question? Second, was the event or risk of non-performance foreseeable? Third, is the performance actually impossible or merely just impractical or burdensome? And finally, can the non-performance be mitigated by the party claiming the impossibility? Just generally speaking regarding these factors, if the force majeure clause specifically references the event in question, courts generally will not focus on the foreseeability factor. So if you have a force majeure clause and it specifically references pandemic or epidemic as a covered event, then the court is not really going to, generally speaking, not going to focus on whether or not the event was foreseeable. Now, on the other hand, if the force majeure clause does not specifically reference the event in question, it will be a highly fact-dependent analysis as to whether the event qualifies under a broad catch-all provision, as I mentioned in the previous slide, something to the extent of any event that is unforeseen by the parties that is outside of their control. And depending on what jurisdiction you're in, some jurisdictions read those catch-all provisions very broadly, where it would be more likely to be included as an event, and some jurisdictions read them very strictly with an eye on not including them. So again, it depends on what jurisdiction you're in. So if we can go to the next slide, we can try to apply these factors to an example instead of speaking about them in the abstract. So let's take a look at an example. Let's suppose an FBO has an agreement with a landlord, and one, the force majeure clause specifically references pandemic as a covered event. Two, the FBO's revenue is down 50% due to COVID-19. And third, the FBO qualifies for loans and will receive loans under the CARES Act. Now, under these circumstances, does the force majeure clause apply to excuse the FBO's rent payment obligations? So under these facts, probably not. And why is that? So we acknowledge that pandemic is actually a covered event under this force majeure clause, and as such, we don't even have to look at the foreseeability element. That being said, however, our analysis doesn't stop there. We have to go forward to see whether or not the force majeure event renders the FBO's ability to pay rent impossible. And here, that's likely not the case. If an FBO is still generating 50% of its revenue, paying rent will be a financial hardship, certainly, but not impossible. And on top of that, when we look at mitigation, if the FBO is receiving CARES Act funding, that will certainly mitigate any claim that they're not able to perform under the contract. So here, even though a pandemic is a specifically listed event of force majeure, it is not likely to excuse an FBO of its rent payment obligations. And just as an aside, I'm speaking about rent payment obligations and being excused from them in the context of contract law only. My colleague Allison Scucciamara will dig into a little bit more detail as that relates to grant assurances and federal law. So if we could take a look at another example, and we'll go to the next slide. So let's assume we have an FBO that has an agreement with a landlord and assume the following. One, the force majeure clause does not reference pandemic as an event, but it does have a catch-all clause stating any occurrence outside the reasonable control of the parties is a qualifying event. Two, the federal government has issued an order closing all airports due to COVID-19. And third, the FBO does not qualify for loans under the CARES Act. Now, under these circumstances, would a force majeure clause apply to excuse an FBO's obligations to pay rent under a contract? Here, the answer is potentially yes. Now, why the difference? You'll notice that here, the pandemic or an epidemic is not specifically listed as a covered event, but when you look at the catch-all provision saying any occurrence outside the reasonable control of the parties, a federal order shutting down all airports will almost certainly qualify as a force majeure event under that catch-all in certain jurisdictions, because it can't reasonably be argued that that's not outside of the party's reasonable control. Again, depending on what jurisdiction you're in, that answer can change, but it's hard to argue that that's something that is not outside the party's reasonable control. And then you look to the next factor, which is foreseeability. If you, if we can go back to the prior slide. Thank you. So if you look at it cannot reasonably be argued that this event would be unforeseeable. I mean, we haven't had a pandemic like this in 100 years, so I think that court is likely to agree. And finally, without any or next to no revenue coming in with airports closed, and if there's no CARE Act funds coming in, payment likely would not be possible as opposed to just a mere hardship. Now, as an example of how changing one fact can change the whole analysis, let's keep this hypothetical example and change one fact. Say an FBO entered into an agreement with a landlord in February or March of this year. Now, that could potentially change everything, because under those circumstances, a court may say that a pandemic, and a airport closure is something that is foreseeable, because at that point in February and March, it was well known that COVID was becoming a national emergency. It was described as a pandemic. So if an FBO entered into an agreement in February or March, they very well may not be able to have their performance excused under a force majeure clause, because a court in that circumstance would say that's foreseeable. So just an example of how changing one fact could really change the analysis completely. And then if we can go to the next slide, and we'll look at one more example. This time we'll look at an example of an agreement between an FBO and a third-party vendor. So let's assume an FBO has an agreement with a third-party company to provide taxi services for the FBO, and then we'll assume that the force majeure clause specifically lists pandemic as a covered event. We'll assume that every driver employed by that company has COVID-19, and third, that there are other third-party taxi services in the area. Now, under these circumstances, would the force majeure clause apply to excuse the company's obligation to provide taxi services to the FBO? The answer to that is probably not. So why is that the case? Here again, COVID-19 is a covered event, and we don't really have to look at the foreseeability factor in light of that. But we have to look at whether or not the company's performance is impossible or impractical. Now, given the fact that there are other third-party taxi services in the vicinity, the company has the option to try and subcontract out to those third-party services to perform that company's obligations under its agreement with the FBO. So they have a duty to try and mitigate, and this may be a hardship and diminish the company's profits, but again, hardship does not equal impossibility. If the taxi company is able to subcontract that work out, then it is not an impossibility, it's just something that is practical or a hardship. So under these circumstances, a third-party taxi company would their performance would not be excused under the contract with the FBO. But again, let's tweak the facts just a little bit to see how it can change everything. Now let's assume that the only difference is the taxi company that contracted with the FBO, they try to subcontract out their work, and the third-party services are just incapable of doing so. Under that circumstance, the taxi company actually discharged its duty to try and mitigate, and they were not able to actually get somebody to subcontract out the work to. Under that circumstance, a court very well may say, well, now it is an impossibility because the company that contracted with the FBO did try to mitigate. We're not able to, and they can't reasonably provide drivers that are sick. So again, it's an example of how this is very fact dependent, and the changing of one fact could change the whole analysis and the whole outcome of whether or not the force majeure clause applies. So if we can, we'll go to the next slide, and we'll just a few additional considerations generally regarding force majeure clauses to keep in mind. So some force majeure clauses may only delay and not excuse performance obligations. So again, every clause is different. You need to look at the particular language. The clause may exclude, let's look at payment obligations again for rent between an FBO and a landlord. A broader clause may say that an FBO's obligation to pay rent is excused. A more limited one may say it's delayed, and the FBO may just be able to delay its payment while the qualifying event continues, but may have to pay the rent back when the qualifying event is over. So again, it depends on the specific language and how broad or how restricted the force majeure clause is. Another consideration, some force majeure clauses may actually specifically exclude payment obligations. So again, we'll look at just the example of an FBO agreement with a landlord. There may be a force majeure clause that applies to excuse the FBO's requirement to provide certain services, but may specifically exclude payment of rent as something that can be excused under an event of force majeure. And finally, something to be aware of is some force majeure clauses will contain notice requirements. So if it's very important, because if a force majeure clause requires you to notify the other party within a certain limited period of time, you want to make sure you do that because you don't want to accidentally or unknowingly waive your right to seek some type of remedy or redress under a force majeure clause by simply missing a deadline. So these are just some of the high level issues involving force majeure clauses and how they may relate to FBOs and their contracts with landlords or third-party vendors. Again, the key to take away is just that it's a very highly fact-intensive scenario, and something worth looking into in detail what your force majeure clause says. And to the extent anybody has any questions at the end of the presentation or any other time, I will be around and happy to take those questions. So with that, I will pass it along to Allison.
Thanks, Paul. That was very informative. I think right here at the start of my portion of the webinar, I can give everyone on the line some comfort in that it's highly unlikely that the FAA is going to be closing airports nationwide or even regionally as a result of the COVID-19 pandemic. As the coronavirus pandemic erupted here in the United States, the FAA's Airport Compliance Office became immediately flooded with questions about what impact the pandemic was going to have on our nation's airports. This caused Kevin Willis, the FAA's Director of Airport Compliance and Management, to release a memo on March 16th advising airport sponsors that airports must remain open and that any proposal to close the airport should be immediately sent to the FAA's Airport Compliance and Management office for them to evaluate and handle the request. So right from the days immediately following the emergency declaration here in the United States, the FAA was looking at making sure that airports remained open and available. Moving on to the next slide. After the April 16th memo that went out, Kevin Willis's office on March 28th issued a much more detailed Q&A type document that was updated on April 4th. The April 4th guidance gave airport sponsors, in other words, your landlords, with some clear instructions on what is and is not allowed to occur at airports during the pandemic. On this slide, I've digested for you the basic details of what is allowed and what is not allowed. So generally, the FAA is going to allow restaurants and retail establishments in the terminals to be closed. It's going to allow closing of gates or sections of terminals to be shut down due to reduced passenger loads. It's going to allow for screening of passengers and quarantining and the enforcement of quarantine orders. It's also going to allow the terminals to be used to shelter people as long as it does not interfere with then ongoing airport operations. The FAA is also going to allow a reduction in hours to the extent that the airport sponsor can demonstrate that it's related to COVID-19. Airport sponsors who are considering such reductions are encouraged to consult with the FAA if they are going to implement some reduction in hours. The FAA also allows temporarily limiting recreational aeronautical activity consistent with public health measures of the jurisdiction. A big one there is, and the FAA specifically calls it out, is skydiving operations and parachuting. Those, if your jurisdiction is limiting any sort of joining together of people and restricting movement, the FAA is going to certainly not look askance at precluding such activity at your airport. The FAA's April 4th memo does also indicate some things that are specifically not allowed. Again, you can't close the airport. If there is a proposal to close the airport, that needs to be presented to the FAA's Office of Airport Compliance and Management, and they need to address any such proposal. You also can't prohibit certain flights. So you can have them screened, but you can't prohibit any single category of flight from coming in, including flights that might have COVID-19 passengers on board. The airport also is not allowed to use runways for overflow parking. Given the downturn in the economy and aircraft movements just really slowing down, there's a need for overflow parking, but you can't take runways out of commission to accomplish that. If you're in an extreme circumstance, the FAA encourages you to contact them and they'll review your specific situation at your airport. Additionally, the FAA says that you can't prohibit flights coming from a hotspot order. So you can screen passengers and you can instruct them to quarantine, you can even enforce quarantine orders, but you can't preclude flights coming into your airport. So you can't preclude, you know, if you're at an airport in Florida, they can't actually preclude flights from New York arriving. They have to allow those flights to arrive and then implement screening and quarantining measures. So the last thing that the FAA clearly prohibits is using airport revenue for health screenings. So if they are doing passenger screenings or quarantining, the funds to do that need to come out of the municipality's other budget. It cannot come out of airport revenues. So that's what we have there. Now, moving on to the next slide, we can talk for a little bit about rent abatements, which I think is particularly useful to FBOs and airport tenants in this case, because you may not be able to avail yourself of a force majeure clause in your lease in order to avoid paying rent. But the FAA, in their April 4th guidance, they talked about rent abatements, and they provide airport sponsors with some guidance on how to approach rent abatements. And generally, they say they're allowed as long as they're based on a changed circumstance caused by the public health emergency, and as long as they're done in accordance with grant assurances 2224 there. So that generally, in accordance with grant assurance 2224, it means that they can't be discriminatory, that any decisions to provide rent abatements must be fair and reasonable, and they can't create an exclusive right. So what that boils down to is if one FBO on the field is offered a rent abatement, another similarly situated FBO should be offered a comparable rent abatement. So if you know that a competitor on the field is being offered a rent abatement, you should be asking your landlord if they can make that same accommodation to you. And certainly if they're reluctant to make that same accommodation to you, you can press back on them and ask them how it is that they can make that accommodation for your competitor, but they can't make that same accommodation for you, and try and ferret out whether or not there's an argument that it's not being implemented fair and reasonably. So generally, your airport sponsor is probably not inclined to engage with you on rent abatements, but these are extraordinary times. And recognizing that, if we can move on to the next slide, the U.S. government has provided for $10 billion of the CARES Act funding to be set aside for airports. So this may, in fact, make rent abatements a little more palatable as an option for your landlord. Under the CARES Act, they're going to set aside $500 million to increase the federal share of AIP grants in 2020. So if your airport is scheduled to receive airport improvement grants in 2020, there is no local share on that. It's going to be 100% funded by the federal government. So there will not be a local contribution, no local matching on that. So then that's $500 million that's being set aside. At least $7.4 billion is going to go to commercial service airports, and up to $2 billion is available for small, medium, and large hub airports. And then lastly, $100 million is being made available to general aviation airports. Now, the funds that the airports receive can be used for any purpose that airport revenue may be used for. So what that means in this context is that they can use those funds in part to assist their tenants, as long as it's for an aviation purpose. So as a result of having the ability to receive those funds, your landlord may be more inclined to engage with you on a discussion about providing a rent abatement. So if we can move on to the next slide. Here we have, some bullet points on an overview on rent abatements. So the airport sponsor is not required to offer rent abatements or deferrals to airport tenants, but they may be inclined to. If the airport sponsor does offer rent abatements, it must make rent abatements available on fair and reasonable terms without discrimination. And that basically means that if it's offering some concessions to one tenant, it should probably be offering similar concessions to another. And if it's not doing that, it may actually cause the airport sponsor to be in a state of non-compliance with its grant obligations. So the FAA guidance acknowledges, and if we can go on to the next slide, that sometimes there are circumstances where rent abatements are just not possible. An example would be if an airport sponsor has certain bonding obligations where they're precluded from providing any tenant with a rent abatement. In those cases, the FAA encourages, and I guess it's more of a suggestion, but almost an encouragement, that the airport sponsor look at whether or not they can provide a rent deferral as a means of trying to accommodate their tenants. The term, like a rent abatement, a rent deferral, the terms and the interest rates, it has to be on fair and reasonable terms. It can't be discriminatory. You can't give a rent deferral to only one tenant and not the other. And any argument that it's discriminatory, not fair and reasonable, or that it creates an exclusive right, which means that it's being only given to one tenant and not the others, those would all, again, create a state of non-compliance and could be a place where you might actually reach out to the FAA in the form of a Part 13 complaint and raise it with them and suggest that the airport sponsor is not implementing any rent abatement or deferral programs in a fair, consistent, reasonable manner as per the grant assurances. And the FAA will take your information. They will likely reach out to the airport sponsor and get the details from them and make a determination as to whether or not there is a state of non-compliance or compliance. And if the FAA finds that an airport sponsor is not in compliance, generally they will request that the airport sponsor take steps necessary to correct any area where they are in non-compliance, which in these circumstances, they'd likely have given the rent abatement, which would obligate them. The only way to correct that would be to give the rent abatement to others or request that the tenant that received the rent abatement pay rent just like all the others. But generally, I think for the most part, you'll see that the landlords will accommodate that by just making it available to everyone. So next up, moving on to the next slide, I want to talk to you about some of the relief packages that may be available to you. I'm going to focus on 4 of them: the Paycheck Protection Program, the Economic Injury Disaster Loans, the Employee Retention Tax Credit, as well as the deferral of the 6.2% employer contribution on Social Security. So the first one up is the Paycheck Protection Program. That applies to businesses with fewer than 500 employees. It's limited to the lesser of 2.5 times your monthly payroll, and your monthly payroll is capped at $100,000 per employee, and the maximum you could receive is $10 million per business. Now, there is, as part of the Paycheck Protection Program, there is loan forgiveness if you are able to maintain your workforce. Now, if you have laid off your workforce, you can still receive the Paycheck Protection Program, but you will not receive the loan forgiveness. Now, if you've laid off your workforce and you bring them back by June 30th, and that's the deadline that's been set, June 30th, 2020, then you would receive the loan forgiveness without any deduction. Now, what can the funds you receive from the Paycheck Protection Program go to? So it can be used for rent, mortgage, interest, utilities, but here's the caveat: 75% of the forgiven amount must be used for payroll. So this program is designed to keep your people employed. So if you've already laid people off and you're applying for this, you want to look at, bringing them back before the June 30th deadline. We have the link here for more information on the Paycheck Protection Program, as well as the application for that. So next up, we have the economic injury and disaster loans that are available. These are designed to be low interest to provide small businesses with working capital up to $2 million. When we talk about a small business, and this applies for the Paycheck Protection Program as well, it's available to businesses of less than 500 employees. So now, if you are receiving funds pursuant to the Paycheck Protection Program, you can't use an economic injury disaster loan for that same purpose. So you can receive both benefits, but you have to use them for different purposes. So you can't be justifying a Paycheck Protection Program effective grant and an economic injury loan to cover those same expenses. There's a streamlined process for advances up to $10,000, and we provide you with some links for more information on them. Both of these programs are administered through the SBA. Now, the next up we have is the Employee Retention Tax Credit. So this is available to employers who have been required to suspend operations or have had a 50% reduction in revenue between March 12th, 2020 and January 1st of 2021. This is not available if you receive a Paycheck Protection loan, and it does not apply to wages under the Families First Coronavirus Response Act. But it does provide you with a refundable tax credit of 50% of qualified wages, capped at, I have here $10,000 per quarter. It's actually $10,000 per employee. So it's capped at $10,000 per employee, and you have to have had a 50% reduction in revenue. And then you will receive a refundable tax credit of up to 50% of the qualified wages for each employee, up to $10,000. So that is that, and just make sure that you note the correction there. It's $10,000 per employee, not per quarter. And if you have questions about the Employee Retention Tax Credit, whether you're eligible for it and how it's implemented, I encourage you to speak with your tax advisor or accountant. The last piece of relief under the CARES Act that I want to put out there for you is that the CARES Act does allow for deferral of the 6.2% employer contribution on Social Security tax. It allows for the sums that you would otherwise be obligated to pay to be deferred, and it applies for the time period of March 27th, 2020 through December 21st, 2020. Under this program, if you do defer taxes, the Social Security, your contribution to the Social Security tax during that time period, you do have to repay that. It's repaid in 2 equal payments. The first of those payments is due December 31st, 2021, and the second is due December 21st, 2022. So with that, I'm going to turn it back over to Olivia, and we'll take some questions. But I wanted to point out to you that we do have a list of resources that we've referenced herein, and these are all available to you by following the links provided. Or you could always check our website at www.lopal.com, and we do have a COVID-19 resources page there. With that, Olivia, I'll let you take it back.
Thanks, Allison. That was very informative, and thank you everyone for participating and for sharing and presenting. We'll now go ahead and unmute everyone who has joined, and you can feel free to openly ask your question, or there is a chat feature in this GoToMeeting. So if you would like, you can just type your question there if it's more convenient. So feel free to, we'll start with whoever has any questions.
I'm not on the GoTo chat, but I do have a question.
Sure, go ahead. Why don't you introduce yourself?
So the deferral for the Social Security for the 6.2%, if you get or partake in the PPP program, can you do both?
Yes, you can.
You can. So you can defer the Social Security payments as well as get a PPP grant.
Yes.
Okay.
The one that you can't is you can't use PPP. You can't use a PPP grant or an economic injury disaster loan for the same purpose. And if you get a PPP loan grant, you're not eligible for the employee retention tax credit.
Okay. And then the employee retention tax credit, you had noted, I think this is Allison speaking, I'm not sure.
Yes.
You had noted that there was, the employee had to work for you for 30 days to get the tax credit. Did I hear that?
No, you're confusing it with the expanded FMLA.
Okay, got it. Thank you.
You're welcome. Any other questions?
To answer Dawn Sailing's question, we will be sending a copy of this presentation out to attendees if they would like it. And it looks like we have another question from Greg Soho of, could rent abatements be granted to one class of tenant and not others, such as grant an abatement to commercial operators and not other types of tenants?
And to answer Greg's question is, that's going to be something that you're going to really have to look at on a case-by-case basis and the facts that surround it. So looking at a tea hanger tenant that doesn't receive a rent abatement, who just uses it for pleasure as opposed to a commercial purpose, comparing that tenant against an FBO, it creates a very different scenario where it actually could justify the FAA only making a rent abatement available to a commercial operator, whereas not providing it to, a tea hanger who's, storing a 172 for, pleasure.
I had another question. Is there a place that you can go to see how much each airport is awarded?
They usually post that information on the FAA's website on the airport, under the airport AIP grant tab. but that generally is usually posted there.
And those funds can be used by the airport at their discretion.
For any purpose that they can use airport revenue. The
Okay,
Rule
thank
25,
you.
Grant Assurance 25, you know, governing revenue diversions going to apply to funds received under the CARES Act. Any other questions before we break? We have a couple more minutes. All right.
We will also be putting this webinar up on our website. We have recorded it, so we'll be putting the recording up on our website if anyone does need to access it after the webinar.
Thanks.
Thank you.
Thanks, Amber. And feel free to check our COVID-19 resources and follow us on LinkedIn to stay current on this information, because you know, this is one webinar we've done, but we expect to do future in you know, as circumstances warrant.
We do have one, looks like Dawn Sailing had one follow-up. They would like to confirm, we had that they had, if they apply for the PPP and it's approved, they have until June 30th to bring back those employees, and they'll still qualify for the loan forgiveness if that was the case that they did.
The answer to Dawn's question is that is correct. You have till June 30th, you have to bring them back, and you won't be penalized under the PPP program.
Any last questions before we send off? I do want to thank the speakers, Patrick, Allison, and Paul Grocki and Amber, for speaking on this matter. And thank you to the participants. Feel free to reach out via our website, or our email addresses are on our website as well. And we'll open it for a few additional questions, but take this time to thank everyone for joining us during this hectic time.
Thank you all. Thank you, Olivia.